in. I'm waiting for Mr. Bress's.
I saw him for a second.
All right.
There he is.
Perfect. I am starting the recording, letting IT know we can begin. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 15-1183 et al. Consolidated Edison Company of New York, Inc., petitioner versus Federal Energy Regulatory Commission. Mr. Bress for the petitioners, Ms. Rylander for the respondent, Mr. Gossett for the respondent interveners.
Good morning, Mr. Bress.
Good morning, Judge Katsas, and may it please the court. The Federal Power Act tasks FERC with ensuring that rates are just and reasonable. Among other things, this means it's FERC's job to ensure that cost allocations, when challenged, are at least roughly commensurate with the benefits received. Petitioners are here this morning because FERC failed to do its job in this case. Petitioners demonstrated with undisputed evidence in the proceedings below that the cost allocations here were vastly disproportionate, even to the inflated benefits that PJM credited them with. For example, they demonstrated that Linden ultimately was allocated 100% of the costs of the Seaworm project, even though it was credited with only 28% of the benefits. They demonstrated that
Counsel, I saw that in your brief. And do you have a principled line which would illustrate where FERC violated the law and where they didn't? What percentage would be the principled line?
Your Honor, I don't know that it comes down to a particular percentage, but certainly these cost allocations are even more disproportionate, Your Honor, than the cost allocations that this court struck as grossly disproportionate in the Old Dominion case. So even if you just wanted to compare it to what this court has previously done, these cost allocations would be disproportionate. But there are administrative law bases, Your Honor, that rise above this, that I think this court can look to in deciding that FERC got this wrong. And I think there are three of them that I would focus on today. One is just a failure to examine relevant considerations because FERC refused over and over to even look at the evidence of the cost allocations that were at issue here, even though it was undisputed evidence. Second, FERC failed to treat like cases alike because it departed without any reason justification from its determination in the artificial island case that the flow-based method can't reasonably be used to allocate costs for non-flow-based projects. And third, it upheld without any reason justification the application of the 1% de minimis exclusion, even though that exempted larger zones from paying their fair share, shifted those costs onto petitioners, and led directly to the grossly disproportionate allocations that are issue in this case. I'd be happy to go through those, Your Honor, unless you'd like me to return to your question, because I don't think there is, we're not asking for exacting precision. This court has made quite clear that that's not necessary. On the other hand, when you've got allocations that are A, incredibly disproportionate, and B, unnecessarily so, that's something that FERC can't say okay to. Another way to think about this is, as the Seventh Circuit put it, if crude is the best that can be done, then crude will have to be good enough. Here in this case, we've demonstrated that the methodologies that were used were inappropriate for these projects, and that the 1% de minimis that was thrown on top of the flow-based method and used with it is utterly unnecessary and just introduces discrimination.
Mr. Bress,
and yes.
Mr. Bress, if I could ask you a question about that. You say in your brief that the de minimis exception is a administrative override, and here you just said it's laid on top of the flow-based method. But my understanding is that it's part of the flow-based method, that it's sort of baked into the tariff. So If you could just clarify what you mean when you say it's laid on top of the tariff.
Certainly, Your Honor. First of all, the de minimis exclusion preceded and predated the flow-based methodology. It was used by PJM prior to PJM's movement to the flow-based methodology. It was when it was still using the violation-based method previously. Secondly, it adds nothing of value to the application of the flow-based method. In other words, the flow-based method works by effectively determining how much each zone uses the new facility or the improved facility as compared to how much other zones use it. I'm simplifying a bit, but that's basically what it does. And then it allocates each a proportionate cost based on their relative use. When you throw in the 1% de minimis value, it exempts certain zones from any cost allocation whatsoever, even if those zones use the new facility far more than the other zones who end up having to pay for it. It's not an integral part in any sense of using flow-based. It actually is contrary to and undermines what the flow-based methodology is trying to do in the first place, which is to allocate based on relative flows. You use this method and suddenly someone who uses it 10 times as much doesn't have to pay anything, and someone that uses it 10 times as little ends up having to carry the other one's load.
It is part of the tariff, so it's applied in
Yes.
every allocation. It's not as though FERC or PJM could choose when to apply it.
Your Honor, we absolutely agree that it's part of the tariff, and I'm sorry if we caused any confusion in that front. Our point is simply that it's not an inherent and necessary part of the flow-based method. If I could start from the top, perhaps. Our
Counsel,
primary.
excuse me,
Yes.
there are a couple of technical questions I have.
Of
Is it correct to say, as you said, that Artificial Island, South Jersey case excludes all non-flow-based interferences? Isn't that an unfair statement?
Your Honor, that case involved stability-based non-flow violation.
No.
And all that the case determined.
Couldn't you just answer my question? Isn't
Yes.
it an overstatement to say that it established the principle that interferences other than flow-based were treated differently? All interferences, whether it's a stability question or a short circuit question, that's not fair, is it?
I think it is fair, Your Honor, even though that case involved a stability-based violation. The essential reading, what a court would consider the holding of the case, was that the flow-based method works and works well and fine in circumstances where what you're trying to achieve is relief of a flow constriction, whether that's voltage-based or thermal-based.
Well, didn't FERC limit their decision to stability?
What it said in that case, Your Honor, is that stability is a unique circumstance, but you can't limit the essential reasoning. A court can't do it and FERC can't do it simply by calling something unique. In other words, in the next case that comes up, you can't throw away the essential reading or holding because you want to come to a different result. And if this court looks to what FERC said in Artificial Island, as this court understood it in the appeal from that case, the entire reasoning that FERC employed in that case was that the flow-based method reasonably establishes the beneficiaries when what you're trying to accomplish for the project is more flow. In other words, if we're putting more flow in the line, those that use that more flow are the beneficiaries. On the other hand, what the court said is that even though Artificial Island involved construction of a new transmission line, use of that transmission line was not itself a benefit because there was no need for additional flow. In other words, the system was already sufficient as it was flow-wise. The
Your
same
argument,
thing is true
excuse
here.
me for interrupting, your argument is the logic of Artificial Island supports you, but you overstated when you stated that it was a holding that any non-flow interference was treated separately.
Your Honor, I accept that. What I would say is that the logic compels the same result.
I
here.
understand your argument. Now, the second question I have, which really mystifies me, is the netting issue. I don't understand it. I don't understand why. I see your argument. I think I understand your argument, but I don't understand the whole question. If we're dealing with flow going both ways, then only one way would go over the new facility. So I don't understand why flows both ways count. I don't get it.
So, Your Honor, I can't explain this, fortunately.
You
So
can?
the answer is I can.
Okay,
I
good.
can and will. I'm doing so now. The way that it's been presented by FERC is as though you've got a river that always goes in one direction, even though there are flows that might be trying to go the other way. It always goes in one direction over a dam, let's say. In fact,
I see. So FERC's position is if there is flow going the other direction, it reduces the amount of pressure going in the direction over. I finally saw it. I see. Thank you.
So that's FERC's position, Your Honor. But in fact, these projects involve, first of all, multiple lines. So they're lines going both directions. Some of them are akin to two-way highways, where the transmission facility allows flows in both directions. And some of them are more like Canal Road, Your Honor, where at certain times they're in one direction and at certain times they're in the other, depending on how much flow there is in one direction or the other. And this method recognizes that. As we've explained in our brief, this method recognizes that there are flows in both the positive and negative direction and assigns costs to the zones that have flow in one direction or the other. They just pretend with netting that they completely offset one another.
But that's wait a minute. Now I understand. Logically, that's correct, because if you're measuring the flow over a new facility to the right, and the transmission, whoever sends a certain amount of flow to the left, that reduces the amount that would go to the right. So therefore, that would be a correct analysis, and netting makes sense then.
So netting would make sense, Your Honor, under a violation-based method, which is where it came from. In other words, if you're trying to see— No.
I'm thinking of it not as a violation-based, but rather the amount of flow that's used over the new facility. If you go backwards the other way, you reduce the amount that you're sending over the new facility, right?
So, no, well, not really, Your Honor, for a couple of reasons. First of all, again, some of these facilities have flow. At sometimes the predominant flow is positive and sometimes it's negative. So saying that because a zone has flow in both directions doesn't mean that it doesn't in fact go in both directions. On some days it goes one way, on some days it goes the other way. You can't fairly net that.
Holy cow.
It's complicated, Your Honor, but this court actually— this court doesn't have to actually hit the merits of it, because FERC has already recognized in the Neptune proceeding that it itself has doubts whether netting is just and reasonable.
Oh, that's raised in the Neptune. I thought it was only
exactly.
I thought it was only the de minimis question.
No, netting as well, Your Honor, and that's been raised in that proceeding. FERC has already held that it may be unjust and unreasonable, and has ordered a hearing on that. At the very least, this court shouldn't permit FERC to come to contrary results in two proceedings that are still live.
Well, we're not allowed to look, we're not allowed in administrative law to look at subsequent proceedings to an order of the court.
Actually, Your Honor, in the Williston Basin case, this court did precisely that. I can give the court the site of it. Williston Basin is at 165 F3rd 54. I'm looking at pages 61 to 63. In that case, FERC came to a conclusion while one case was up here being reviewed. FERC came to a conclusion in a different case it was looking at that went precisely the other way. This court remanded so that FERC could treat like cases alike. And it wasn't asked to remand by FERC. It was the court's decision to do so.
But in this case, FERC hasn't yet decided either the de minimis or the flow question or the netting question.
No, and Your Honor, to be fair, our view is that the de minimis issue is clear cut enough that this court should address it straight out.
But not
there really isn't.
Not so much for netting, which you didn't start with.
We'll acknowledge, Your Honor, that netting is a more technical issue, and it's appropriate for FERC to look at both cases in the first instance. With
So
de minimis,
suppose we think on netting, suppose we think there are reasonable arguments on both sides. And on the one hand, that cuts in favor of FERC. If it's reasonable either way, their decision is not arbitrary and capricious. On the other hand, it might cut in favor of not getting in front of Neptune. But I mean, we don't usually hold one case just because it has an overlapping issue with a pending administrative proceeding. So what do we do in those?
And we're not asking, Your Honor, we're not asking that this case be stayed or held in abeyance. We've been held in abeyance for many years already. Our request would be as to netting, Your Honor, that when this court remands the case and vacates for other reasons, that it direct FERC to decide the netting issue the same way as to both proceedings, so as to not treat, again, like cases unlike. We do believe that this court should, as I said, flat out hold that the 1% de minimis exclusion is unjust and unreasonable. There is and has been no rationale put forward in either law or logic or fact for it. The only things that FERC has said are, number one, when it came up with this 1% de minimis, it said, well, we want to make sure that non-adjacent zones are not held responsible for remote and distant projects. Here, of course, they're not throwing that argument to this court because PSEG itself was excluded, and that's the zone in which the projects are being done and for whose customers benefit they're being done. So FERC here has two arguments it's made. One is that the 1% de minimis is a non-discriminatory and efficient way to ensure that zones aren't tasked with costs for benefits that are small in relation to their overall use of the grid. We think that accurately describes what the 1% de minimis does, but the fact that it discriminates in favor of larger zones efficiently is a problem, not a benefit to it. Secondly, FERC has suggested that, well, sometimes they redo the defects calculation every year, and so who gets benefited and who suffers the consequences of the 1% may differ over time. That's, again, not much of an excuse for it, Your Honor. If it's an irrational methodology that leads to unjust and reasonable cost calculations, the idea that, well, sometimes it might work in other, to hurt other people or help other people, again, isn't a rational justification for it. Besides, here, we know that it operates systematically. It operates systematically to help larger zones because they're more likely to be exempted, and to hurt smaller zones who are less likely to be exempted. And that led, here to really extreme results. The empirical data that we presented the court with and we presented FERC with directly came out of the 1%. So when we learn that Hudson and Linden had only 10% of the flow-based method benefits, and yet were forced to pay 86% ultimately of the costs of the corridor project, that's solely and entirely due to the application of the 1% de minimis convention. And so it has led here, and that's true of all of the statistics that we used, to the results we're faced with. Now, FERC, we gave those results.
Mr. Ress, could you just explain to me why, as a practical matter, was it not apparent to Con Ed that this would be the result of the application of the tariff? Because all of these provisions were set out in the tariff. Why did it come? Was it a surprise that this was the outcome of the calculations?
So we're talking just about de minimis right now, Your Honor?
Yeah, about the de minimis.
Yeah. Your Honor, what de minimis was defended as when it first came out, again, was a method that was going to really just work to ensure that distant zones were not held responsible for costs to which they had only sort of very small connection.
That's not.
And I know the math is the math.
Yeah.
I realize the math is the math, Your Honor, but in most projects, most of the flow-based projects that have been an issue at FERC, there have been 1,200 of them that are flow-based, and we haven't seen these kinds of results come out of them. These projects are different. They have produced different results, Your Honor, And it couldn't have been predicted earlier because the whole modeling technology that PJM uses is a proprietary technology. And so trying to predict it first, yeah, we could have seen that it was irrational, but trying to predict it first who it was going to hurt, and therefore who has standing to challenge it, wouldn't have been something that we could have done. There are a lot of things that are wrong in life, Your Honor, but we don't complain about them unless they're going to hurt us.
So I have another question then about that. So is the relief that you suggest that the tariff itself is unjust and unreasonable because it leads to these unjust and unreasonable cost allocations? So
As applied,
right, as applied to the petitioners here. So is the solution to that to say that the tariff is unjust and unreasonable, or that FERC should have given the petitioners some type of exception here, the way they did for Artificial Island? And what difference does it make to the petitioners if we choose one remedy or another?
Your Honor, petitioners don't care, because in this circumstance, petitioners are no longer using the services within PJM that would allocate these costs to them going forward. So long as FERC does its job and reforms the rates, petitioners are satisfied. And one of the difficulties we have,
but the relief is going to be prospective from the filing of your complaint, right?
Or from our protest, Your Honor. We also filed.
In other words, we wouldn't say that the tariff was unlawful as applied going back to day one.
No, Your Honor, just from the date of our protest, basically, to these complaints,
right,
and then our actual complaints under 206 ourselves. And Your Honor, just one last point, if I may, which is the third point that I was going to hit today, is that FERC failed to take into account relevant considerations when it just completely ignored our undisputed empirical evidence of the grossly disproportionate allocations here. Now, what FERC said is, we don't have to look at what actually comes out of the methodology. We just have to look at whether the methodology itself is just and reasonable. The problem with that is the Federal Power Act says that rates must be just and reasonable. And when FERC is presented with rates that on their face are unjust and unreasonable, it can't shrug and say, yeah, well, the underlying methodology.
Yeah, the problem with that argument is you have no principled line to draw at which the disproportion between benefit and cost is too much, number one. And number two, you're challenging the ex-ante approach that FERC has developed. Now, it seems to me your argument is stronger on the de minimis. Now, let me go back to Artificial Island again. I had one hell of a time trying to understand FERC's technological explanation as to why Artificial Island was different from your case. Could you explain why you think they're the same? I know you can make a general statement saying all non-flow interferences should be treated the same, but that's not what FERC said. Can you give your criticism?
I'll do my best, Your Honor. Yes. So,
in other words, they made a distinction between stability and short circuit.
So the only distinction that they made, Your Honor, in the order here, which is all we can look at, the rehearing order where they addressed Artificial Island and its application to this case, is that they said the solution in this case is more like the solutions that you come up with in cases that involve flow constraints, in other words, thermal and voltage constraints. The problem with that argument is that the solution here was building new transmission line. That was the same solution that was used in Artificial Island. In Artificial Island, that new transmission line created another pathway, an additional pathway from generators to the grid. In this case, the new transmission lines bypassed circuit breakers that were not up to the task. In neither case, though, were those transmission lines created like they are in flow-based projects in order to enable greater flow. And because of that, you can't measure benefits here by the flow that goes over those transmission lines any more than you could in Artificial Island. So the only distinction they came up with really isn't a distinction at all, because it's the same in both cases. What FERC said, by the way, to be clear, is FERC addressed the fact that there was a new transmission line in Artificial Island, because as this court will recall, the transmission owners didn't like the results in Artificial Island. And they said, well, there's a new transmission line here. And what FERC said is, sure, there's a new transmission line, but because the old transmission facilities already carried the DeMarva party's power just fine, the fact that their power is now going to ride on this new line doesn't give them any benefit. The same thing is true here, Your Honor. There was no constraint of flow that was going on. We were already using. I'm sorry, Your Honor.
But I see your point. But on the other hand, in the stability situation, you can solve the problem by building any number of transmission lines going to anywhere, right? You can connect Artificial Island to Delaware, you can connect it to Philadelphia, you can connect it to Cape May, right? And so there's an element of capriciousness in figuring, which of those non-flow necessary lines will be built, and then who will get saddled with the cost if you apply defects.
Sure.
That's not really true for short circuit. I mean, if the problem, let me state it and then tell me why this is wrong. But if the problem is that the circuit breakers going from A to B, right, Bergen to Linden or wherever, if the circuit breakers can't handle the flow or whatever else is associated with that line, 99 times out of 100, you fix the circuit breakers, but this is the 100th case where you fix the breaker problem on the A to B line by upgrading A to B. You upgrade the transmission line, which is what the Bergen project was. And that seems like it's much more in the model of you're improving transmission from A to B, even if you're doing it for collateral reasons, as opposed to the stability situation where the line only needs to radiate out from the nuclear plant.
So, Your Honor, I don't think that's a correct understanding. First of all, the short circuit problems, and no one, not even FERC, has said that the short circuit problems were just along sort of an A to B to the Bergen corridor. In fact, there were short circuit problems here in Newark and in Jersey City. The short circuit, let me just take a step back, is something that is a surge in current that is caused by lightning strikes and the like, right? Where current can suddenly go 40 times as high. And if you don't stop the short circuit current, it can melt or even explode facets of the system. So, for example, if a short circuit current is not stopped, it could blow up a substation. And the problem that occurs there, and of course, what you're trying to solve when you're curing for a short circuit is, it means that the load that is served from that substation no longer can be served and the lights go out. That's a huge problem for PSEG because the local load is the one that primarily suffers. Sure, everyone else's electricity gets rerouted in some way, but they still get their electricity. So it's a local problem, and that's why when you just get a new circuit breaker, the tariff provides at page 1975 that the local utility pays 100% of the costs. Here, instead of fixing it that way, they didn't improve the network to fix it or improve the lines to fix it. They literally bypassed. They created transmission lines that just bypassed what they call overdutied circuits. In other words, circuit breakers that weren't up to the task. So they created a loop around them, that sort of thing, to bypass them. But that doesn't provide us a benefit just because our traffic now goes on that new line, Your Honor.
But I mean, one of the shorthand descriptions for the Bergen project, I'm sure this is oversimplified, but just on the A to B point, is that they upgraded that particular line from 138 kilovolts to 345 kilovolts on that line. And I'm sure a little bit of knowledge is a dangerous thing, but to me, that sounds like they're upgrading that line.
Your Honor, there's no doubt that along the way, they gold-plated what they were doing. In other words, they did more things than just cure the basic short circuit problem. But the purpose, of course, of the project, and you can look at JA 378 or JA 176, unquestionably was to address the short circuit problems. It was the primary benefit of the project was to solve those problems. And to be clear, FERC didn't defend the result here otherwise. It didn't say we're treating this case differently from how we treated Artificial Island because there are substantial other benefits that are created, and the flow-based method is the way to measure them. They've never advanced that as a rationale, Your Honor. They're free, of course, to try to do that on remand, but given that the only thing they've done is a one-sentence comment that the solution here looks a lot more like the solutions that you use in flow-based is I would say intolerably so. You're to use this court's own terminology.
Unless you go back and dig into Mr. Hurling's testimony, which I actually did, and I think,
and I have, Your Honor,
consistent
and
with
of course
what I've been pressing you on.
And of course, Your Honor, if you look at Mr. Hurling's testimony, he treats short circuit problems and stability problems the same way. So did PJM generally. And so did PJM's president, and FERC relied on all of this PJM input to decide the Artificial Island case. So I fully would embrace Steve Hurling's testimony here, Your Honor, and just say that what he said and what PJM said didn't draw any lines between the two.
Okay.
I'm sure I've gone way over my time for my affirmative presentations.
Judge Rao, anything else? Judge Silberman?
No.
Okay, thank you, Mr. Bress. We'll give you some
Your Honor.
Rebuttal. Ms. Rylander, you're up.
Good morning. May it please the court, Elizabeth Rylander for the commission. I'd like to go to the essential point of this case, which all three of your honors asked questions about, and that is why this case is not the same as Artificial Island. And the commission's best explanation.
Can I just start where Mr. Bress left off, because this was on my list of questions for you, which is, if you look at Hurling's testimony, he does not distinguish stability issues from short circuit issues.
The commission dug into that, Your Honor, in the technical conference, where it took an entire day with experts from parties.
Excuse me, you may have looked into it in a technical conference, but I'll be damned if I can understand your explanation. It's your burden, is it not? Under APA, the party that wishes to defend an order has the burden of proof, burden of persuasion. And neither in your brief nor in the FERC's opinion could I understand the logic. And if we can't understand the logic, aren't we obliged to remand?
Yes, Your Honor. But if you could please clarify which logic.
The logic that distinguishes Artificial Island from the present case. What did you say in the brief?
That's where I would like.
You were pretty.
That's where I'd like.
Excuse me. You were pretty terse in the brief, and you certainly didn't give enough to explain it. So, so then I look back at the order, and I couldn't figure that out either.
Okay. I hope this will also address Judge Katsas' question at the same time.
It is the same.
Okay. The reason this case is different from Artificial Island is that when you're resolving a stability constraint around, which in that case was around a nuclear power plant in southern New Jersey, it's important to carry electrical flow away from the source of the problem. And the strength of the grid in that area was not sufficient to carry enough power away. So as Judge Katsas said earlier,
what was the stability problem?
The stability problem refers to the operation of the plant itself. If not enough power is being carried away, it can cause it can cause problems with the rotation of the electrical equipment generating power within the facility. So you don't.
It's an exterior issue other than flow.
Exterior in that it's part of the grid. The grid has to carry the flow.
Analytically exterior.
Yes. So in order to solve a stability problem, you carry power away from the problem. And in order to solve a flow-based problem, you carry power to the problem, i.e. there's not enough generation to serve load. And that's what happened. That is what was happening here is the short circuit problems and impending thermal problems on this North Jersey project were making it more difficult, or would soon make it more difficult, for PJM to carry load, to carry power to the places it was going in North Jersey and New York.
I'm not sure that's right. If you look at the technical conference again, the way they seem to be conceiving of short circuit problems is that the breakers are as strong as the breakers are, and as the flow increases over that line and the breakers stay the same, at some point the breakers don't become not strong enough to support whatever flow is going over that line. Is that not right?
No, that is right. But the solution is that similar to solving a thermal problem, you need to build additional transmission capacity or install additional equipment to carry more power. But the essential point, as your honors brought up earlier, is that FERC did not make this exemption from the flow-based method according just to whether the violation in question was non-flow based. It's in Artificial Island, it subdivided that category and found the exemption was only for stability related issues. In this case, FERC drew the same technical distinction that we discussed earlier, and determined that it was that the nature of the upgrades were such that the flow-based method did appropriately allocate costs and could be reasonably applied to this case. As Judge Rao asked earlier regarding what Con Ed could and couldn't foresee, all of the rules are set out in the tariff, and this flow-based method has been uneventfully allocating costs for 9 years to a total of over 1,200 projects.
That's not in dispute in this case.
Correct. It is not in dispute. And it's
so I don't know what that has to do with the price of tea.
What it means, Your Honor, is that in a case like this one where the rate works the vast majority of the time, the commission has held that there's a very high chance that it's just and reasonable. And what the petitioners say that they want here is just an exception. They say they don't care what the court decides in terms of whether the rate is or is not just and reasonable. They just don't want to pay the costs that they're owed.
May I ask a question about the de minimis rule?
Yes, Your Honor.
How in Lord's name can you defend the logic of that rule?
The de minimis
So if I'm a real big guy, I can avoid any cost responsibility if even though you use a massive amount of electricity from a particular source, as long as it's a small percentage of my total load. What's the logic of that?
Yes, Your Honor. The de minimis rule is set in terms of percentage as opposed to a number of megawatts or some other measure. In order to measure the total impact of a zone, I'm sorry, I'm looking at the wrong place in my notes. The intent is to prohibit the assignment of costs to far distant zones. For example, as the Seventh Circuit noted in Illinois Commerce Commission, to prevent the assignment of costs to Illinois for these upgrades being built in New Jersey. The reason it's set as a percentage is that everybody has a percentage.
So the New Jersey utility, which is PG something or other, is a far distant operation. Far distant from where?
No, certainly it's not a far distant utility, Your Honor. But
So
what we know,
so what is this relevant to?
what we know we can't do is assign costs far out of the zone. And what there seems no principled way to do is to choose a number of megawatts that should be exempt. So the commission has opted for percentages. And as noted in the very beginning of this argument,
it's a percentage, but a percentage of the wrong denominator.
Yes.
The point of this method is to measure what for any given facility, what's the percentage use by any particular utility. And instead of using that percentage to cut off de minimis users, your denominator is not total use of the facility, it's total use by the utility, which is going to be wildly arbitrary when you have situations like this one where one of the utilities at issue is 30 times bigger than other ones.
Again, Your Honor, the commission in applying what has been baked into the tariff since the beginning said that that's not the case, and that it is a non-discriminatory way.
Not the case that my description of the percentages is wrong.
What the commission said is that it's a non-discriminatory way of ensuring that costs are allocated only to the zones that benefit. I do understand Your Honor's point that public service electric and gas is a very large zone.
Rylander, so even if the tariff itself is just and reasonable, its application here to PSE and G, and to the petitioners here, isn't that allocation itself unjust and unreasonable because of the application of the tariff in these circumstances? A circumstance you've acknowledged wasn't the one that the de minimis rationale was implemented for?
Judge Rao, I'm sorry, I missed the beginning of your question. Could you ask it again?
Yeah, so my question is, this de minimis convention is a different type of circumstance, right? Where a utility is far away from a particular facility. And here, even if maybe the tariff in general is just and reasonable for most applications, its application in this case seems to be wildly disproportionate. Isn't FERC required to ensure that the allocation is itself just and reasonable?
Certainly it is, Your Honor. And the commission and PJM have spent many years developing, first in FERC's case, a rule to ensure appropriate allocation of costs, and in PJM's case, a rate that accurately makes that allocation. What happens when you start to look at every single cost allocation after the fact is that the ex-ante principle of the rate is undermined. The idea is that everybody understands ahead of time by reading the tariff how cost allocation works, what they can reasonably expect, and how the allocation process will play out. Here, the rate identifies beneficiaries over years as the grid shifts and changes. And PJM found that both parties both in New York and New Jersey benefit. There will certainly be instances, and the petitioner's brief does refer to individual sub-projects, not to the project as an entirety, where it looks as though the netting and de minimis made larger exemptions than than they felt were warranted. But they talk only about individual pieces of these projects. They don't talk about the projects. They don't talk about the projects as a whole, particularly the Bergen-Linden project. So what I'm saying is that I think where you started off in your discussion with petitioners is that it's very important that there be settled expectations in terms of how PJM will analyze beneficiaries, how the cost of those beneficiaries will be allocated, and who is presumed to benefit.
Right, but Ms. Freilander, I absolutely take your point about the importance of setting ex-ante rules for allocations, but Old Dominion suggests that FERC cannot simply rely on the fact that it has an ex-ante rule, right? It also has to examine whether the particular allocation is just and unreasonable if that's raised before it.
Mm-hmm. And
how to balance those two things. I mean, I think that is I think the real question I have. I mean, in a situation where, say, maybe the tariff is just and reasonable, what is FERC's obligation to evaluate whether a particular allocation is just and reasonable? It can't simply say, well, apply the tariff properly. So what does it have to do in the particular application of the tariff?
So this case involves both filings under Federal Power Act 205 and under Federal Power Act 206. And as I was explaining earlier, FERC expects that because the formula here is sound, it will produce good results. And in those Federal Power Act 205 cases, it ensured that the tariff was followed and that the results were as expected. That's the court order, the subprojects order, and so forth. But FERC has always allowed, and in this case entertained on 3 separate occasions, Federal Power Act 206 challenges to the rate itself. I can't remember exactly what this procedural setup was in Old Dominion, but that is, but regardless, FERC has provided the same opportunity to petitioners here to challenge the way the costs were allocated.
Old Dominion was you approved an amendment for a certain category of projects that we thought didn't work. And we were sensitive to this concern that rules are rules and you don't have to go around creating an exception every time you think the rules might not work. But we also were careful, or we tried to be careful to say that the distinction that we thought you were missing in that case was between high voltage and low voltage lines. And that was one that the commission itself had told us was important.
Yeah, and certainly, Your Honor, I am quite familiar with the case. I just couldn't remember Federal Power Act 205 versus 206. And in Old Dominion, what we had approved, as you said, was an amendment to this very cost allocation that's at issue here, to limit the allocation of the cost allocation for high voltage lines. We've not done anything like that here. This is the cost allocation that has been, again, approved uneventfully, allocating costs in more than 1,000 projects for some years.
So on that rules are rules point, one conclusion that you might draw out of that is that this is a collateral attack on the tariff, but FERC does, the interveners make that argument, but FERC does not. So do you have a position on that question?
We did not raise that argument because, again, FERC has allowed parties to raise challenges to individual findings as an artificial island. But here, as there's no issue of an exception or a change to the rate. So I would say broadly, no, I don't think this is a collateral attack, but an as applied challenge in which the petitioners are requesting an exemption from the rate.
It's tough sledding for them if you posit that the general rule is fine qua rule, and they're saying, well, but it doesn't work well in this case. And assume for purposes of argument, I think if you think of this as did FERC did FERC explain why one might reasonably think of a circuit breaker case as being akin to a flow case?
Mhm.
Maybe I agree with you on that, but we're still left with artificial island, and you did what you did there, and it seems like you need to give us some reason why to justify treating circuit breakers different from stability, and I think that's the tough part of the case for you.
Stability, again, Your Honor, is electrically and analytically a strange situation in which, as Your Honor pointed out, is discussed in the tech conference, you can build a transmission line going anywhere and it will help the situation. And then at that point, the designation of who benefits becomes very arbitrary. It could be Philadelphia, it could be Allentown, could be, as in this case, Delmarva, which did not need the power. So there, the flow-based, yes.
Excuse me. Your colleague, your counsel on the other side said in the case before us, there was the same transmission lines built to avoid the circuit breaker. Is that correct?
I'm sorry, I'm not sure I understand your question, Your Honor.
I'm not sure I understand it either, but he did say that in both cases, transmission lines were built to get around the problem. To get around the problem.
Yes, there were, in both cases, transmission lines were built, but the distinction
to get around
here,
the problem, right?
To carry power away from the problem in artificial islands. And yes.
I'm sorry if I'm being imprecise when I said get around the problem, but of course I'm referring to power.
Okay.
I wasn't referring to pencils.
Okay. The critical difference legally between this case and artificial island is that in artificial island, the flow-based method did not accurately identify the beneficiaries because of the arbitrariness of where that new line goes. And in this case, where the facilities were built, and the commission said at least twice in the orders, these facilities this project is an upgrade to facilities used to carry power to New York, then the benefits do follow the flow of power. And you can tell who's benefiting by doing the flow-based analysis and seeing where the power goes. Con-Ed's contract allows it to take 1,000 megawatts from PJM. The merchants take another 600 and some megawatts. It's a significant amount of power that's going to New York and that these facilities are supporting.
In artificial island, what FERC eventually came up with is something called a disruption analysis. In other words, you would allocate flows, you would figure out what happened, who would be harmed if the stability problem came to fruition, and you would allocate flows. The benefit being measured is avoiding that harm, and you would allocate flows accordingly. Why wouldn't that same logic apply here, which is you're not building or upgrading the line to enhance flow. You're building the line to prevent a separate problem, which is the circuit breakers fail, which could cause all these explosions and such. So why couldn't you just figure out what would happen if that, who would be harmed if that very bad contingency came to pass, and then allocate benefits in terms of avoiding that harm? Seems like that's pretty analogous.
The replacement rate that was developed on artificial island was not at issue in the appeal. No one ever challenged it.
It goes to the underlying question of whether circuit breaker problems are more like artificial island or more like run-of-the-mill upgrading the line projects.
It sounds as though if you're looking at who would be harmed, that sounds more like a violation-based analysis to me. And the commission has some time ago.
Who would get the benefit of not having explosions when the breakers fail?
Who would get the benefit of not being harmed?
Fair enough, but that's a little bit different from the violation question, which would ask who caused the situation, who caused the circuit breakers to no longer be good enough. It's not that question.
And I suppose the commission or PJM could look at the problem that way, but it hasn't and it doesn't. It looks at benefits from the flow of power, which this court mentioned, which this court said only the week before last was a reasonable way to identify beneficiaries under the flow-based analysis in the Long Island case. There's certainly, that I would bring that back to the essential question of this case, which is not whether some other rate might be just and reasonable, but whether this rate is just and reasonable. The commission certainly could have resolved this case some other way. It certainly could have weighed the evidence. It could have come to some different conclusion. But what the court's task here is to decide whether the conclusion the commission did reach is a just and reasonable one. And I would say again,
well, but our problem, counsel, our problem first is to fully understand the FERC's rationale. And if it has not been articulated either in the order or in the brief adequately, then what is our appropriate response as the judge?
Your Honor, is there, you've asked several specific questions about how to distinguish this case from Artificial Island. It sounds as though, it sounds as though Your Honor's not yet reached Your Honor may have further questions.
No, my problem, I don't know about my colleagues, is I don't find the explanation that FERC gave distinguishing the two situations adequate. That's my concern.
I would say that the commission is not required to carve out exemptions for arguably different subcategories of projects. The commission went to an extraordinary amount of effort to analyze this case, including issuing 17 or so orders, holding a technical conference, setting it for settlement on 2 separate occasions, and in the end concluded that this case was different enough from Artificial Island that the approved cost allocation that everybody expected should apply. I am happy to try to continue. I'm happy to continue trying to help understand where the distinction comes from.
Judge Silberman, anything further on that?
No.
Judge
No.
Rath? I guess just one more from me, I guess, which is to what extent does the commission have concerns? Put aside what should happen in this case, but to what extent do you have concerns about de minimis and netting as reflected in the Neptune proceedings?
The Neptune, the order of the complaint proceeding in Neptune stated only that the commission was interested in gathering more information. Briefs and responses have been submitted, and the commission is considering the matter. There's no ruling yet.
And if you were to afford relief in Neptune, would that just, if you were to agree with the concern, would just change the tariff provisions going forward? And then Mr. Bress's, all of the clients involved in this case would effectively get relief going forward?
I don't want to speculate on exactly what the commission might or might not do. I can say that the refund effective date in that complaint proceeding was set, I believe, December 31st, 2020. And there were questions asked about what would occur if the commission ruled a certain way. And the best thing I can say is that we will address that at the appropriate time. But the matter remains pending before the commission.
Okay. Do my colleagues have anything else?
No.
Okay. Thank you, Ms. Rhinelander. We'll hear from Mr. Gossett for the interveners.
Mr. Gossett, I think you're muted. Mr. Gossett, you're muted. I can't.
Sorry, Judge Rao. Yes, I had turned off the Zoom mute, but not the mute on my microphones. I'm very sorry about that.
You're fine. Go ahead.
Several technical problems this morning. Good morning, Your Honors. In my limited time, I want to touch briefly on 5 points, all very, very quickly. And the first, and I think it's important to return to that, because all the judges, all 3 judges have flagged it, but I think we need to remember its importance, which is that FERC in this system designed this process to be an ex-ante process where these costs are allocated in advance, and that we don't necessarily sort of go through exactly the endeavor we're involved with here. Judge Rao pointed to the Old Dominion case where, and for the proposition that FERC has to examine whether that system led to a clearly flawed allocation of costs, but they did that here. That's part of the technical conference, and frankly, that, to my mind, is the real lesson from Artificial Island. I mean, the technical conference addressed both Artificial Island and the Northern New Jersey projects, and FERC determined that one situation was sufficiently extreme to warrant an exemption from the ex-ante system, and the other was not. So
where is the substantial evidence within the technical conference to support FERC's assertion that the Bergen-Linden circuit breaker problem is more like a routine upgrade than like Artificial Island?
I'm pulling up my copy. I believe I wrote that down as being page 1166. Yes, where it says, circuit breakers are components that are parts of facilities that carry flows. In the end, it's a component of the interconnected grid whose purpose is to carry flows. So you can measure against those flows to see who's using those facilities. That's in the technical conference. And where I was actually going to point the court in response to Judge Silberman's questions about whether FERC had said this in its orders, were in 2 separate places. First, on page 362 of the Joint Appendix.
Sorry, let's just tie down.
Sure.
Let's just tie down 1166, because I don't read that as supporting the proposition that Artificial Island and Bergen are different. That's really an argument that making an exception for either would be moving too much back to a violation-based method.
At page, well, I didn't interpret it that way. I believe it was, because it specifically differentiates the two, because it's about circuit breakers being a component that it carries existing flow. And I think that's the critical point here is, my friend Mr. Brest wants to claim that the distinction is whether a problem is flow-based, but I think the real issue is whether the solution is it can be appropriately determined based on flows. And so again, in the technical conference, and I believe this was at page 1140, that's where in the technical conference there was further discussion of the proposition that Judge Katsas, you, and I believe also Judge Rao made about how, with respect to Artificial Island, it was almost random on whom these costs would be allocated because it just depended on where Artificial Island was connected to the net. It could have been 90% in Delmarva, it could have been 90% in Pennsylvania, based on that connection. But here, and this is true of a thermal load problem or a circuit breaker problem, there is an existing facility. That facility has a problem that needs to be fixed. And in fixing that problem, you see who benefits from that facility. So
and when you say, and just to be clear, when you say facility, we're talking about the transmission line from Bergen to Linden, from A to B, right?
As well as the C. Warren facility as well, but yes.
But just simplifying.
Yes.
Bergen versus Artificial Island. Bergen is an A to B problem. Artificial Island is an A to anywhere problem. Is that fair?
And at page 362 of the joint appendix, which is in one of the commission's orders, they specifically make this point, and they say, in contrast to stability-related reliability issues for the Bergen-Linden corridor project, PJM must upgrade or reconfigure the transmission system specifically to reduce short-circuit current on the overdutied element in a manner similar to the planning process for resolving thermal overloads. That's the commission's own words saying, the distinction between thermal and short circuit is wrong. The distinction is between stability like Artificial Island and projects like Bergen-Linden or a traditional thermal problem.
I see it, but you do have to squint a little bit.
You do, but Your Honor, that's where it's important also, of course, to remember that FERC is the expert here. I mean, I am hard pressed to come up with a case that is more technical and deeply involved with FERC's expertise than this one. They looked so carefully at this over the course of an 8-year period to make these nuanced distinctions between the two projects.
Mr. Gossett, why when, if the Bergen project is a kind of A to B project, why, I guess maybe you can explain why that isn't about stability from A to B, right? Why is that more about flow? Because in part, the artificial island is about stability in a particular place, in a particular facility. And this maybe, one could say is about stability on a particular line. It's not about increasing the flow. It's just making sure that the flow in this one corridor is done without any short circuits.
Your Honor, stability is, as I understand it, a technical term of art. And the real issue with respect to Artificial Island is that it's power generation, and it's a stability problem with respect to the generation of power at these 3 nuclear plants on Artificial Island. Stability is not a question of, is the line stable? If the Bergen-Linden line had a short circuit and a fire and blew out, then power would not flow to New York in the way that they have a contractual right for it to work, to get. And therefore, they are directly affected by a stability problem on this line, just as they'd be directly affected if there was a flow problem because too many people are trying to get energy over this line and we can't get enough energy to the people that have a demand on it. Both are about this line. And let's just call it the A to B line, as Judge Katsas said. And there's a problem with the ability of energy to flow across this line to its recipients. And the New York entities were major recipients of this. The 1,600 megawatts of power that we're talking about here is the equivalent of 2 nuclear plants worth of energy. This is not a small amount of energy we're talking about that flowed to New York City through these projects. I'm mindful that I'm sort of over my time, but if I may, I would like to briefly touch on the de minimis point, which does work here. It's designed to eliminate small diffuse benefits. So that's why it was designed.
But it doesn't do that. It would be a perfectly sensible rule if the cutoff were percentage use by the individual utility relative to total use of the facility. But that's not how this cutoff works.
But it's designed to see how much the utility cares about it, which
I have to say, counsel, I thought that was an ingenious effort to provide an explanation for FERC. But I don't think it quite works. First of all, FERC didn't use it. But secondly, I don't think it quite works.
Well, it's what
I give you a lot of credit for imagination.
Thank you, Your Honor. I do think it was what the parties intended, and I also think it's what the tariff says. I also think it's important to look at some of the numbers here, because the petitioners talk about the de minimis problem as if it's about exempting PSEG from paying for this project. But if you actually look at the numbers, at JA 135, you see that the effects on PSEG are actually quite small. For Bergen-Linden, it reduces their allocation of costs from 17% to 7%. And for Seawarren, it's from 4.8% to 0%. So it's not like most of this cost would otherwise have been on them. JA 551 is a chart, or 552 is even better, is a chart that shows that the vast majority of the effect of the de minimis rule is exactly what it's supposed to be, which is exactly what Judge Katsas says it's supposed to be, which is about exempting all of the 22 sort of zones in PJM that are far away in Illinois or Ohio from this, because their effects are small. But really, a de minimis rule is a decision by the members of PJM on how to allocate the costs of a project. It doesn't allocate costs to someone who doesn't bear a large burden. It exempts certain ones of them, and that's reasonable. The rule that Judge Katsas seemed to be advocating for, that it should be based on 1% of use rather than 1% of that entity's use, is certainly a reasonable rule, but that doesn't mean that the rule is not.
It's not just some reasonable rule plucked out of the air. It is what solution-based defects is measuring.
Solution-based defects is measuring to whom the power goes, but then the question of how to allocate that cost is one that is not just a question of applying a formula. It involves some choices made by the PJM members about how to divide up those costs. And the choice that they made was to include a de minimis rule of this form. They can change it. And indeed, of course,
but the conceptual point, tell me if I'm wrong, but the conceptual point of solution-based defects is if PSE&G uses 10, and I may say this imprecisely, I'm sorry, but you have some new facility, and PSE&G uses 10% of it, they should bear 10% of the cost, right?
No, Your Honor, that's not it. Well, because of course, solution-based defects, and this was a point of Judge Rao's earlier, is a system that includes a vast number of specific formulas and conventions about how you determine the allocation. And the de minimis rule is one of the very bases of the system. It's not an exemption. It's part of the formula for deciding where to allocate the costs. And the decision made by the PJM members was that what they cared about was, in allocating the cost, was who actually cared about this project. And who cares about this project depends on how important it is to them. And a project that only sort of is relevant to 0.8% of a utility's energy flows isn't very important to them, whereas a project that is affects 20% of an entity's flows is very important to them. And that's true irrespective of the absolute number of how much energy flows over them. It's about relative importance, not about relative use.
I think we understand I think we understand your position on that. Judge Rao, anything else? Judge Silberman?
No.
Okay, thank you, Mr. Gossett.
Thank you, Your Honors.
Mr. Bress, rebuttal.
Sorry, Judge Katsas, and may it please the court. One preliminary note, we agree, by the way, that just shifting costs to PSEG wouldn't cure the whole problem. But that's not actually a saving grace of the 1% de minimis. It actually damns it. If this court were to look at, for example, JA 576, it shows with regard to the Bergen or corridor project, who has what percentage of use with and without the de minimis. And what it shows is that there are certainly other entities, not just PSEG, who had greater use, for example, than Linden or HTP, and that were exempted. And the problem is, you can say they're more distant, which is one of the things FERC said is we don't want to attribute costs to more distant zones. They're really misusing the Seventh Circuit's holding there. The Seventh Circuit was saying, well, more distant zones that are using these new facilities less shouldn't have to pay most of the costs. Here, solution-based defects is purporting to tell us how much they actually use it. And we're just saying, let's charge them for how much they use it rather than give them an artificial exemption. Number two, I'd like to correct one factual issue, if I may, that has, I think, crept into the discussions here. The court has been addressing whether the short circuit issue is something that is caused by flows. And it is not something that's caused by flows. It's caused by short circuit currents rather than by flows. This is at 537 of the JA. If the court would look at that, there is a description of how this works. What it says is that that to determine the beneficiaries of a project designed to address short circuit violations, it's not reasonable from an engineering perspective to use the flow-based method because instantaneous fault currents rather than steady state energy flow are key components of the problem. Energy flow is not a contributing factor to short circuit violations. Now, there's no evidence in this record to the contrary, because that's actually how it works. Short circuit currents are just caused by instantaneous surges caused by lightning or such. They can be caused by how much generation is on the line, but they're not by generators that are near the line, but it's not proportionate to flow. So the idea that it is incorrect. Next.
Sorry, help me out with that, because I did not looked at 537, 538.
Yes.
Was working off of Hurling's testimony, and he seemed to describe the short circuit problem as one that would become incrementally more acute as projects are built and flow expands. Is that not right?
It's not quite right, Your Honor. It's basically as you get more generation on the line, it's actually, and again, we're getting pretty technical for me, but it's actually caused by the amount of inertia that's in the generators that are feeding into the line, not by the amount of flow that the line happens to be carrying. In any event, if I may, I'd like to address the ex-ante issue. This court addressed it already in Artificial Island. In Artificial Island case, the transmission owners, as they do today, came in and said, well, the whole point here is to have an ex-ante system, and you can't change it just because you don't like the results as to a particular project. This court rejected the transmission owner's argument directly, and it pointed to three things. Number one, it said, or actually two are relevant here. Number one, it said that Order 1000 itself requires as its first in principle rule, the cost causation principle. That is its very first principle, that costs must be allocated in a way that are roughly commensurate with benefits. Number two, the court pointed out, so in other words, there's no inconsistency with ex-ante. The cost causation rule trumps ex-ante. Number two, the court pointed out that certainly whatever Order 1000 says Section 206 of the Federal Power Act trumps it. The next point is that the tech conference did not look at the results. There was an argument that was made here that the tech conference looked at the results. You can look in vain through the tech conference, and nobody adverted in that conference to the cost misallocations that are at issue in this case. So the tech conference had nothing to do with that. Next, there's an argument that there's no need to make distinctions between
Suppose, counsel, we were to conclude that the FERC's rationale in distinguishing the two was perfectly logical. By that, I mean artificial island in the present case. Would the disparity in cost any longer be relevant?
Well, the disparity would be exactly what it is, Your Honor. It would be relevant because the disparities that we've pointed to are entirely caused by the 1% de minimis convention.
Oh yeah, put aside the 1%.
Well, that's what's causing the disparities.
You make a powerful point. Put aside the 1%. You understand my question. If we thought it was a logical distinction between artificial island and this case, then the misallocation of costs, in your view, would be irrelevant, wouldn't it?
Yes, Your Honor, only because if we're putting artificial island to the side, all of the numbers that we've presented the court as to the misallocation have to be put to the side too, because those are all just the result of the 1% rule. So in other words, if you take that rule out, we don't have empirical
in other words,
evidence
even if you
that there is a misallocation.
Your point is, even if we were to disagree with you concerning artificial island, but agreed with you on the 1%, the major change would be made in terms of cost allocation?
It would eliminate the cost misallocations that we presented to this court. The empirical evidence of cost misallocations would disappear.
Well, then artificial island is irrelevant.
No, Your Honor, it's not. See, what our proofs are that even if you accepted flow-based method as a correct method.
Wait, I want to make sure I understand. If we agreed with you on the 1%, then what I've just heard you say, the misallocation of costs and benefits would be solved without ever discussing artificial island.
No, Your Honor, and let me try to be more precise in my answer for you. The numbers that we've presented, such as Linden and Hudson having 10% of the allocated benefits and 86% of the allocated costs, those numbers are purely a result of the 1% rule. However, putting aside the 1% rule, we have the same issue here that Delmarva had in artificial island, which is there's also a basic non-quantitative problem here that leads to misallocation, which is they're measuring the wrong thing. By measuring by flows.
Wait a minute, stop. So you made clear at the beginning that if without the cost problems, you wouldn't have an injury. So are you now are you now telling me that if you prevailed on the 1%, you no longer have an injury?
No, Your Honor. I'm saying is
what is your injury if you prevail on the 1%?
Even if we prevail on the 1%, the methodology for determining our benefits, we'll agree at that point that if you buy into the methodology for determining our benefits, at that point, costs and benefits will be allocated correctly. The problem is that the methodology for determining the benefits to begin with is flawed.
Counsel, you're not really responding to my question. If we agreed with you on the 1%, is it correct to say that the misallocation of costs and benefits would disappear? And therefore, why is there any relevance to you? Because you made very clear in the beginning that if there wasn't a misallocation of cost, you wouldn't have an injury. Why does the artificial island issue or the claim that it's these should be treated the same? Why is that any longer relevant to your case?
All right, Your Honor, the answer is the cost misallocation doesn't disappear. One component of it does. In other words, the numbers we've presented the court with are assuming for purposes of argument that the flow-based method correctly identifies our benefits. We are still being charged far more cost than that because of the 1% issue. But now we can say that we also don't think that the flow-based method is correctly determining our benefits. It is overestimating our benefits to begin with. So in other words, the real cost misallocations are larger than the numbers we've presented.
It sounds like you're saying these two issues are belt and suspenders for you. Are you saying that?
No, I'm not, Your Honor.
In terms of real world.
Your Honor, if I can try one more time on this. The numbers we've presented that show the gross misallocations are based on the assumption for purposes of argument that the flow-based method, for example, correctly says that Linden gets 28% of the benefits of the Seawarren project. And our argument about the 1% issue is, gosh, because you apply that, you're not charging us 28, you're charging us 100%. So that's the effect of the 1% issue, and that would cure that problem. But we're also arguing that the idea that we get 28% of the benefit to begin with is also wrong, because the flow-based method is an incorrect and unreasonable method to determine our benefits to begin with. We believe our benefits are actually far less than 28%. So yes, giving us the 1% gives us a lot, but not everything.
Does it matter in terms of the cost to you?
Yes, absolutely, Your Honor. So we have paid $150 million, Your Honor. If you strike the 1%, that will give us about half of what we've paid back. We still think that the 75 we're left with is an overcharge because the flow-based method isn't an adequate method to demonstrate the benefits that we get from curing these short circuits or from storm hardening Seawarren. That's all.
Is your position then that the petitioners owe nothing for these upgrades?
Absolutely not, Your Honor. A couple of answers. First of all, happy to pay our fair share. Secondly, if for the high voltage parts of projects or sub-projects within these, as this court recognized in Old Dominion and is recognized before, there's a 50-50 methodology. So in other words, some of the costs are already being paid for those sub-projects on a postage stamp basis for 50% of it, and by solution-based defects for the other 50%. So we're already paying on a postage stamp basis our fair share for the high voltage projects. Our complaint on those projects is we're being overcharged for the other 50%. For the low voltage projects, we're not claiming that we should owe nothing. We're saying, as Judge Katsas had indicated before, and I'm not ascribing a conclusion to you, Judge Katsas, we're just asking the commission to do the same thing it did in Artificial Island, which is to tell PJM to go back and say, look, who benefited from fixing this problem? There it was who benefited from fixing the stability problem. Here it's who benefits from fixing the short circuit problem. We're happy to pay our fair share of those benefits.
Okay, Judge Silberman, anything else?
No.
Judge Rao? Okay, thank you, Mr. Bress.
Thank you so much for your time.
Case is submitted.
So they're still injured, even if they're still injured, even if.
And just let me know when you're ready.
Case number 20-1079 et al. New Jersey Board of Public Utilities petitioner versus Federal Energy Regulatory Commission. Mr. Schierenbeck for the petitioner, Ms. Chu for the respondent, Mr. Townsend for the respondent interveners.
Mr. Scherenbeck, good morning. The floor is yours.
Good morning, Your Honors, and may it please the court. This is a familiar administrative law case. An agency didn't meaningfully respond to critical arguments, and it thought its regulations could trump a statutory mandate. Those errors require vacatur, and here they are particularly troubling because FERC's failure to engage in reasoned decision-making leaves New Jersey ratepayers on the hook for hundreds of millions in costs for a project that was built in substantial part to serve New York, not New Jersey, and which continues to deliver important benefits to New York cost-free. I think there are really three distinct errors on review. First, in relieving Con Ed of all further cost allocations for the corridor project, FERC mistakenly thought that as long as its decision aligned with one piece of a FERC regulation, Principle 4 of Order Number 1000, it didn't have to ask whether its decision comported with its duty under the Federal Power Act to ensure that rates accord with the cost causation principle. Second, FERC's decision to allow Linden to escape cost rested on a flawed premise, namely that by converting its transmission withdrawal rights, Linden gave up important benefits like reliable service and the right to have PJM upgrade the grid to accommodate Linden's needs. But that conclusion turns on the failure to meaningfully consider a critical issue. By opting for firm point-to-point service at the same time, Linden did not give up those benefits. And third, this court has held that FERC must consider whether the total effect of its rate decisions adds up to an unjust result, not just the reasonableness of each subsidiary part. And here FERC held just the opposite, that so long as each part of its decision was sound, it didn't have to look at that bigger picture, which saddles New Jersey with hundreds of millions of costs. And that error also separately requires vacatur. So I would begin with Con Ed. And the statutory duty is to conduct the cost causation analysis. And this court has said, and FERC itself, I think, has recognized that no one part of Order 1000 is sufficient to trump that statutory mandate. But if you look...
No, but this case is about the imprecision or deviation, whatever you want to call it, from cost causation introduced by Principle 4 of Order 1000. And this court specifically upheld that in the South Carolina case. So to the extent the New York entities are, Con Ed is doing better than it would under pure cost causation, it's just because they're out of zone. Their responsibility is limited by their contractual commitments. And their contractual commitment was crystal clear that once they get out of the wheeling agreement, their responsibility ends.
Yes, Your Honor. And we're not making a general challenge to Principle 4, its soundness as one of the competing principles that must be balanced in a cost causation analysis or a cost allocation analysis. It's that here, as applied, singular attention to that factor was inappropriate and irrational.
What is it?
What about the point Judge Katsas made about the contract itself? Isn't the contract crystal clear that Con Ed has no liability once it stops service?
It is, Your Honor, and we're challenging that like you challenge any tariff provision that's clear, but as applied, unjust and unreasonable.
Well, weren't you part of that contract?
Yes, Your Honor, but the settlement itself actually made clear that it wouldn't be treated under the sort of extraordinary standards of Mobile Sierra doctrine or as kind of anything special other than an ordinary contract that would be subject to just and reasonableness challenge, which is why I think FERC didn't lean on the 2009 settlement as anything that required any kind of different sort of analysis here. So we're not disputing the 2009 settlement allowed this. And taking a step back as to why it is unjust and unreasonable to treat it this way and why Principle 4 doesn't get you all the way there in relieving Con Ed of all costs. It's that here, the 2009 settlement mandated that PJM build upgrades to serve the Con Ed wheel. And so Principle 4 doesn't really address what do you do when one party is legally compelled to build the upgrades, and then FERC simultaneously gives that other region the right to exit when it sees the bill. And maybe FERC on remand, after this court says you have to take another look at it, will start to think through how Principle 4 should apply to that unique factual circumstance, but it's the one that's teed up here.
But what is unusual about what happened here, right? I mean, we just had a very long argument about, stability issues are different from flow issues. So you can understand that. What is different? What happened here that makes this something other than just the heartland application of Principle 4, where the upper bound on liability is what's in the contract?
One answer is that the settlement legally compelled one region to build projects to serve New York. And I take Principle 4 to be talking about, to be imagining voluntary contract. And here, of course, the settlement was entered into by all the parties, but it can't immunize for all time and in all circumstances inequitable distributions of costs. And so placing that burden, the compulsion to build the project, and then having a right to unilateral exit, that's what, as Con Ed saw fit, that's what really, I think, distinguishes this circumstance. Of course, if the corridor project could be abandoned, practically speaking, when Con Ed backed out, that might change the calculus, but that's another thing I think FERC would have to look at on remand. Here, the corridor project was already well underway, and when Con Ed terminated. And I want to focus on the nature of the error in the decision, because I think it's clear on the face of the order on review that FERC thought so long as Principle 4 was met here, it didn't have to do any other analysis. At the top of JA 153 in the rehearing order, it said that Principle 4 required the result of relieving Con Ed of costs. It talked about benefits to New York as being irrelevant and immaterial at JA 152 and JA 153. And at the very least, you have to balance all the different principles of order number 1000. And we think FERC failed to do that here. FERC also said it wouldn't hold an evidentiary hearing to even consider those benefits and burdens that New York had imposed and was continuing to benefit from because they were irrelevant and immaterial.
Yeah, the order does have language to that effect, but fairly read, it has an independent ground of decision. One ground is compliance with Order 1000, and that's the end of everything. But there is another independent strand of reasoning in this order, which is letting the New York entities out of responsibility is reasonable because they have foregone benefits, and seems a little dicey as to Linden, but it seems pretty clear as to Con Ed.
I agree on the benefits side that the Con Ed argument is weaker than the Linden argument, but on the burden side, the Con Ed argument is fairly strong, and at the very least, the commission didn't grapple with this question. I mean, the whole of the commission's analysis as to the extent to which Con Ed led to the creation of the corridor project is confined to a footnote 85, and on page 108 of the JA, and it says, PJM says the corridor project would have been necessary even if there were no flows to New York. And then without endorsing that analysis at all, it says, so we can't agree that the bulk of costs are being stranded, which I think implies maybe some substantial part other than the bulk is being stranded. And that's the end of—
Incidentally, counsel, FERC made a factual finding here, did it not, that the project would have gone forward without regard to service into New York?
I don't read the orders that way, Your Honor. I read the orders to allude to PJM's statement that they would have gone forward, but not to make that finding itself. At the very least, what FERC didn't do is grapple with PJM's earlier statements that we cite in our complaint and in our brief, saying that the corridor project was, the substantial cause of the corridor project was these flows to New York, and reconcile that with PJM's change of tune. I would say at JA 263, PJM had earlier said fault current levels from the Con Edison system were a cause of the corridor project. In the other proceeding that you just heard this morning, you have FERC saying, well, it's very difficult to determine who's the cause of a problem like this, but you had PJM earlier, clear as day, saying that the Con Ed system was a reason for it. And now you have FERC saying before you, well, we know the Con Ed system wasn't. And I don't know how to square all of those things together. What I do know is you have to take a hard look at this issue if the reason for the corridor project was the Con Edison system, and that could be a reason why Con Ed needs to continue to carry costs. And I take the FERC's major response here to be that our argument is a collateral attack. I think that's wrong for three reasons. The first is that they didn't raise this collateral attack issue below, and basic Chenery principles, and this court has applied them directly in the context of the collateral attack doctrine, require the commission to raise it. The second is that prior proceeding was distinct. It was about whether the Con Ed wheel was continuing. Ours is on the assumption that it had ended. And the third is that there were ensuing events that made the board take this route. Namely, it was not until this complaint was only filed after it was clear that all of the costs would not be reallocated from Con Ed to Hudson and Linden, but onto New Jersey ratepayers.
You can maybe debate whether this is best characterized as a collateral attack issue or an administrative issue preclusion issue or something else, but the fact of the matter is you're attacking your own settlement here.
And I would point you, Your Honor, to the provision of the settlement. I believe it is on JA 618, paragraph 28, which says that the just and reasonableness standard is going to govern all future disputes about the terms of the settlement. It says Mobile Sierra doesn't apply. You're not going to treat this like some kind of special contract that deserves some kind of special weight, and that the parties can bring challenges under the just and reasonableness standard, which I think is why the commission didn't make any kind of argument about Mobile Sierra below.
No,
or
they did rely on the settlement.
That's right, Your Honor. And our position is somewhat tautological because the settlement is just integrated into a part of the tariff. And it's like when the commission also says, well, the tariff allows Con Ed to escape these costs. Well, yes, that begs the question of whether it's unjust and unreasonable to apply the tariff here. And if there are no further questions on the Con Ed side,
let's move on to Linden.
Yes. And, we think that the problem with the Linden analysis is that it leaves out an important part of the picture. If you consider
I think you have a strong argument on the merits, but walk me through where you spelled this out in your rehearing motion.
Yes, Your Honor. So I would point the panel to pages 522 to 524 of the JA. That's our rehearing petition itself. And I'd say we raised it. The commission understood we raised it, which is why they addressed it.
Why don't you read the point that you're making?
Absolutely.
I don't recall it.
I understand. So
Read
what we
the
say,
actual language.
I will. What they say.
Let me first say, in your brief, you make the point that the agency responded to the notion that you're raising. So therefore, that's implicitly an indication that you raised it. That's not quite logically true. What FERC made a statement, but it's not a statement that was ever challenged by you, a statement concerning Linden. But I didn't see that, making the same point my colleague is, I didn't see where you challenged the interrelationship between the point-to-point concept and payment and the withdrawal.
Yes, Your Honor. So I think we have three answers. And again, it's the specific language, the fact that the commission understood that we raised it.
Please read.
And I will.
I don't see the commission's response as in an indication that they understood you raised it. They just made that statement. Now,
So-
where did you actually raise it?
Yes, Your Honor. So what we say, and this at first on page 522, we talk about New York ISO's statements about continued transmission reliability and resource adequacy benefits. At 523 and 524, we say New York ISO has even acknowledged that amendment of the ISAs, that's the contracts at issue here for Linden, and the continued to connection to PJM does not limit New York from receiving reliability and capacity benefits via merchant tie lines like Linden.
Yes, but that
Now-
doesn't go to your much more sophisticated argument that you make in your brief concerning the interrelationship between the point and the withdrawal.
So what I would say, Your Honor, is we
You
were
make the
pointing.
you make the argument in the brief that the change from firm to non-firm withdrawal in light of the point was really irrelevant in terms of benefits. I didn't see that in the rehearing, and I certainly didn't see it in the FERC's response to your rehearing.
So what I would say, Your Honor, is when we're talking about the acknowledged continued reliability and capacity benefits, that is this argument about point-to-point service. And then that's where I would transfer Your Honor's attention, if I could, to the order itself on rehearing, where the commission understood what we meant and then specifically addressed it in this context. Now, remember, we're the only party that filed for rehearing. So the commission is responding to the board's arguments. And it said the commission explained that merchant transmission facilities with non-firm TWRs do not receive the same service and benefits because PJM can curtail or interrupt the withdrawal service for reliability and economic reasons.
Sorry,
Irrespective.
what page are you reading from?
J151, Your Honor. It's paragraph 13.
Yep.
It's in that second sentence.
Okay.
Irrespective of the priority of any upstream firm transmission service, right? So that's upstream firm transmission service. That's exactly what we're talking about.
They made a statement, but it's one that you did not challenge with the rather elegant argument you put in before us.
Well, I appreciate the compliment, Your Honor, but I think that I respectfully disagree about what was before the commission and that the commission understood the argument to be made. Because if you then go down to footnote 25, which is the footnote that follows this allusion to firm transmission service, you'll see the commission is saying the possibility of Hudson and Linden receiving capacity benefits from New York ISO is outside the scope of this complaint. That's the argument we're making on 522 and 524, that you have to look at the capacity and reliability benefits that Linden is still getting through New York ISO. And even if Your Honor thought, look, they didn't say point to point exactly, so I'm going to close my eyes to point to point. If that's where you were, I wouldn't go there. You'd have to agree that what we raised was the fact that Linden can continue to sell capacity in New York ISO. And the commission said, we don't have to look at that at all because that has to do with New York ISO's tariff. And I would submit, Your Honor, that's irrational because an MTF exists between two markets. And to close your eyes in a cost causation analysis to the selling market altogether is to ignore a really critical piece of the cost causation analysis. So even if you thought that...
Let's assume that you hadn't even made that the argument that you make before us. And FERC was on the operating on the assumption that non-firm withdrawal was different because PMJ could reduce the withdrawal at any time. That could still allow Linden to sell in the capacity market, right? We don't know about that. That's a question for New York.
Hypothetically, but it's the why. It's the why that really gets you there. And if you look at page 1042.
In other words, one of my question is, that could have been true even under your, even if your argument hadn't been made. In other words, it depends on the rules in the capacity market. And even if, for instance, Linden was not totally reliable because its withdrawal rights could be curtailed at certain time, that still might decide, New York might decide it's still worthwhile to take them into the capacity market. So it doesn't follow necessarily that those are inconsistent.
I would say two things, Your Honor. One is that, yes, of course, it depends on the structure of the New York ISO market. But if you're looking at the benefits that Linden receives from these rights, that to close your eyes totally to the benefits they receive in the New York ISO market is unjustified, or at least unexplained here. And then second, if you look at the why New York ISO agrees that they can continue to sell capacity into the New York into the New York market, you'll see it's because everything the commission said about the effects of conversion are wrong. And I just want to point you again to J151 and that footnote 25. The independent power producers case that they're citing in direct response to the board's argument, in that proceeding, New York ISO says clear as day that conversion by Linden doesn't affect the reliability of the service they receive. That's
let
at
me
page.
ask you
Yes.
a practical question. If the decision had been contrary to the decision that FERC made, and Linden was, the cost to Linden overwhelmed its revenue, wouldn't Linden have been bankrupt almost immediately?
That may be right, Your Honor, although, whether Linden can continue as a going concern, that might just be that they can no longer buy really cheap power and sell it into New York. I mean, that's, sometimes you are a market participant and things don't work out, but that would be their argument as to the measure of cost allocations.
I recognize that's the real world, real people, rather than a legal argument. But I was wondering, that putting this cost on Linden would be like trying to get water out of a stone.
Well, they really, look, it depends on how badly New York wants this power, I suppose, and what Linden's actual contracts say. Because if the costs of buying the power in New Jersey go up, but New York still really wants this power because it has a voracious desire for power, well then, maybe those contracts will be negotiated and Linden will keep going.
Is this a relevant consideration at all?
I think it would be.
That Linden would have gone broke pretty quickly.
I think, Your Honor, it would be relevant potentially to the measure of costs that Linden is going to bear, but not whether converting its rights is an on-off switch for those costs.
Mr. Scherbeck, can I ask you another question on the maybe it's more to the merits of your loophole argument? FERC suggests that for point-to-point transmission, there are some baked-in costs of upgrades. So so when Linden makes these point-to-point contracts, they are in fact contributing to the cost of upgrades through, through those. So maybe, if you could respond to that.
Absolutely. I think FERC and the interveners pointed to other kinds of costs rather than the transmission enhancement charges that we're actually debating here. And we think they're both distinguishable. There's the upfront costs that a merchant like Linden pays when they interconnect to the grid. I would point you to opinion 503 at JA 733, which distinguishes those upfront costs from the sort of ongoing costs that one has to pay to ensure reliable service in the regional plan process. And then as to the border rate, which is the rate attendant to point service, that rate bakes in a kind of generalized cost sharing of regional plan upgrade costs across the whole grid. So a utility in Ohio will be paying some fraction of the share of the costs of the Oregon Corridor project because, well, the grid is generally mutually beneficial. But what it doesn't do is allocate any of those direct costs. And so it's to say they're paying some fraction of these costs through the border rate attendant to point service just isn't directly responsive to whether they should pay a share of the direct costs as a direct beneficiary. And
so is it, I mean, just so I understand, the baked in cost, what you're saying is a very small percentage compared to what the direct costs would be to pay for that upgrade?
Yes, Your Honor, because it's distributed across the whole grid, everybody in PJM, I should say, then it's just a fraction of the cost they would pay if they're being analyzed as a direct beneficiary of the project because their flows go right over it.
Thank you.
And so, and in fact, I'll just point you to, there's also an allusion, I think, by interveners to an ongoing proceeding that covers the point-to-point service. And they say, well, look, if you have a debate about paying more, go take it down that line in the point-to-point service proceeding. But in that very proceeding, I'll point you to 177 FERC 63027. The ALJ has determined that transmission enhancement charges, that is the exact same thing we're talking about here, are outside the scope there. And so there's a bit of like a shell game going on where every single proceeding where the board raises these objections, FERC determines it's not the appropriate place to raise them, which is why we brought a holistic challenge to try to get at the totality of this question, which is the stranding of costs in New Jersey. If there are no further questions, I'll save what time I have for rebuttal.
Rao, Judge Silberman,
No questions.
we'll give you a few minutes. Thank you.
Thank you.
Ms. Chu.
May it please the court, Susanna Chu for the commission. Judge Katsas, Judge Silberman, you're exactly right that this case is about contract principles. When you make a comment that the commission is not just taking a narrow view of Order 1000 here, the commission actually did take a holistic view of what was happening here after the parties that challenged the cost allocation in the first case decided to exercise their contract rights and surrender firm transmission rights that had been the triggers for the cost allocation.
Well, the contract point is very powerful to you on Con Ed, but I don't see how it moves the needle on Linden, because one of the orders that we have before us is one in which FERC changed the underlying contract commitments to allow them to convert from firm to non-firm withdrawal, which may be a perfectly fine thing to do, but it just means you can't assess the reasonableness of what's going on here just by saying, well, look at the antecedent contracts.
A couple points to that, Your Honor.
Go ahead. I have a point I would like to make in connection with that. Go ahead, answer
Okay.
Judge Katz's question.
Right. So the underlying form contract, the commission determined there that it would not be just and reasonable to hold Linden, to require it to continue to pay for service that it no longer wanted. This is a market, and here, these are business entities making judgments on a daily basis. And here, the commission held that it's not just unreasonable to hold a business to require it to continue to pay for a service that it considered to be too expensive. Now, it's also important to remember that New Jersey Board of Public Utilities did not actually challenge that conversion. They did.
Yes, your point. Yeah, that's the point I was about to get. You claimed in your brief that was not legitimately before us because you made a separate decision to allow the shift from firm to non-firm, and the petitioner never appealed.
Right, Your Honor. In our brief, we did discuss that.
So what FERC seems to do is slice these cases up into little, very narrow slices of salami, and nobody knows what the overall implications are. Is that a strategy on the part of FERC to make it?
No, of course not, Your Honor. It's not a shell game. We're not slicing up these cases. This was an extraordinarily complex set of cases, of course, dating back to 2015 or even earlier.
When you made the decision to allow Linden to switch from firm to non-firm, was it your view that the implications on that for cost were all before everybody, and therefore implicitly suggesting petitioners should have complained then if they had this objection?
Yes, Your Honor, that is right. The commission made the decision to allow the conversions in the orders underlying the petitions in case numbers 20-1080 and 20-1081. But the New Jersey Board of Public Utilities, in its request for rehearing, is generally challenging the outcome, the fairness. They don't like the outcome. And the commission has considered throughout all of these proceedings and in the orders on review here, the actual outcome of these market rules. At the end of the day, the commission concluded that it was not unjust and unreasonable after the New York entities had already paid some significant amounts towards these upgrades. It was not unjust and unreasonable for New Jersey to bear the costs for upgrades that PJM had decided were needed, and they're necessary whether or not there were flows over these transmission lines to New York.
My understanding of petitioner's position is they didn't object to the change from firm withdrawal to non-firm withdrawal because the cost implications were not obvious at that point. Is that correct?
I think that maybe, I'm not exactly sure when petitioners believe that the cost implications were obvious, but in the commission's view, the cost implications were actually obvious years ago. Going back to the settlement agreement between Con Edison and New Jersey and
But
other parties.
you're not taking the position that there's collateral estoppel here.
We actually do, Your Honor. I mean,
this is an unfair collateral attack. Are you taking that position?
we do actually believe it is an unfair collateral attack. I mean, of course, we rest on the fact that the outcome here is just and reasonable, and the commission did make factual findings on this. As Your Honor was pointing out, the factual findings that these upgrades were required, they were needed in PJM, regardless of flows to New York. But yes, we are also making the collateral attack argument because this case does not arise in a vacuum. It arises against a whole series of orders addressing these contracts. So going back,
there's a real problem that we've seen with respect to whether petitioner has legitimately raised before the agency in a rehearing petition the rather interesting and persuasive argument they make before us. But let me ask you about the merits on that. Is it fair to say that the shift from firm to non-firm, given the obligations to on point to point and the benefits from point to point, is really an illusion? That is to say, the notion that with a non-firm withdrawal arrangement, the Linden is really prejudiced in a position they would be in, not being in a firm withdrawal. They make the argument just that with the point to point, it doesn't really matter. What's the answer to that?
well, so two things, Your Honor. Yes, first of all, the argument absolutely is waived. It's raised nowhere in New Jersey's rehearing request. But on the merits,
indulge us though.
On the merit, yeah.
Just discuss it on the merits.
Yeah, yes, Your Honor. So on the merits, the commission did find that there is a difference between firm and non-firm withdrawals. PJM no longer has to plan for these megawatts going over its lines to Linden, Hudson, and Con Edison. These are, Linden relinquished valuable rights in this case. The commission also
I don't understand why PMJ no longer has to plan if in fact the non-firm withdrawal rights give Linden everything they really had before. It's just a change of insignificance. Then why wouldn't PMJ have to plan for it?
Well, the commission actually found that it does not give Linden everything that it had before because PJM can actually curtail those flows as needed. They can interrupt those flows. And the commission absolutely did find that. And actually the independent power producers case that Mr. Scherenbeck has referred to, the commission did find that it is the New York system operator's decision how to treat the power flows that are moving from New Jersey into New York. But FERC, from its perspective, like the power flows, the withdrawal rights are not the same. And also, the commission did find that for this point-to-point service, Linden, Hudson, and other parties, they do pay a share of PJM upgrade costs as part of that. And that's in the complaint order at paragraph 57, JA 111.
Incidentally, counsel, what's the status of Hudson in this case? Are they on appeal? Are they here before us? It's a little puzzling.
I understand the question, Your Honor. Mr. Townsend will speak on behalf of Hudson, but our position is that New Jersey has waived all its arguments against Hudson. It has barely made any arguments about it throughout the opening brief. The brief seems to challenge Con Edison and Linden's lack of cost responsibility. Barely mentions anything about Hudson, except in a general way, the overall cost allocation. That's how we understand it.
So can I ask you about the independent power order?
Yes, Your Honor, of course.
It seems a little bit hard to parse, because on the one hand, FERC does repeat this point that if you have non-firm withdrawal rights, those can be curtailed regardless of priority of the upstream transmission, point-to-point rights. But on the other hand, the New York ISO, its argument is not, gosh, these rights have been degraded in New Jersey, but they're good enough for us to allow the company into the capacity argument. That is not into the capacity market. That is not what they say. What they say is that the combination of firm point-to-point service and non-firm withdrawal rights is the same as having firm withdrawal rights. And FERC embraces that, at least to the extent of saying it's reasonable enough to uphold their decision.
Right, Your Honor. So I think you're looking at this decision. At JA 1051, the commission discusses this. I think the bottom line is that it is New York's decision, the system operator's decision, as to what level of firm transmission right is sufficient to be considered capacity in its market. But the commission also says that we correctly previously recognized that non-firm transmission withdrawal rights can be curtailed. They can be curtailed before a firm transmission withdrawal can be curtailed. So,
which is to say that the commission disagrees with New York's position that point-to-point, and now I'm just quoting from FERC's summary of New York's position, the New York ISO's position at 1042, you say their position is that what Linden now has is no different than long-term firm transmission reservations, which could only be curtailed as a result of a level 5 event.
yes, I see that, Your Honor, but that's where the commission is just reciting the New York system operator's opinion. So the commission's opinion is really in the discussion.
Are you accepting that or not? And
we are accepting it as the New York system operator saying it's adequate for its purposes. And this actually does lead to the border rate litigation that Mr. Scherenbeck mentioned.
Sorry, I keep interrupting you, but I'm just having real trouble with this because their theory for why it is sufficient for their purposes is that it's just as good as what Linden had before.
Right. I think that their position is that because the firm point to point it's firm, the transmission service within PJM is firm. Even if the withdrawal right is not firm, that's sufficient for New York's purposes. And that's really an answer for New York to provide, for the system operator to provide. They have decided it's sufficient.
Excuse me, counsel. Is your response that New York simply thought this was good enough? It didn't for a capacity market. And FERC affirmed that as a legitimate judgment.
Yes, Your Honor, exactly.
But it may be good enough for the capacity market, but not necessarily perfect. That it could be curtailed. So did you ever say that FERC, that New York was correct to say firm withdrawal and non-firm withdrawal were equivalent? Did New York say that? And did you approve that?
No, New York.
You understand my question?
I believe I do, Your Honor, and I think you're exactly right. If I understand you correctly, you're right that New York never said that a firm transmission withdrawal right is the same as a non-firm withdrawal right. But it did say that combined with the firm point-to-point service, that was adequate for purposes of the New York system operator. And the commission did find that that's a legitimate judgment for the New York system operator to make.
Yeah.
Have I answered your question, Your Honor?
I think so. How important was it to FERC that Linden would have gone broke pretty quickly if you imposed the costs that petitioner wanted?
I think that must have factored into the decision, Your Honor. But really, the commission's conclusions here are based on the operation of the contracts and of Order 1000 principles.
Well, the contract, as my colleague, Judge Katsas, has pointed out, is really relevant vis-a-vis Con Ed, not so much Linden. Right.
Right, Your Honor, but it's right. But in addition, I've only touched on it briefly here, but we briefed it. There are prior orders of the commission that basically spelled out what would happen if New York entities relinquish these rights. And we discussed it in a brief, but it's the 2017 joint operating order and the 2019 rehearing order, in which we discussed the impact of Con Edison leaving the transmission service agreements. And it's also, it's opinion 503, which was cited in the orders, where the commission found that, this is actually going back to 2009, that if a merchant transmission facility converts from firm to non-firm, that they would no longer be responsible for these transmission upgrades in PJM. So all in all, the commission here was looking at everything that had happened before and in the course of this case. And it did conclude at the end of the day, Judge Silberman, you were right, that the commission made the finding that PJM had determined that these upgrades needed to be built. It was absolutely critical for reliability that they be built. I know Mr. Scherenbeck actually referred to a page in the joint appendix to talk about how fault currents from New York may have caused the short circuits, that JA 263, but that's, I believe, just a page in New Jersey Board's complaint. The commission never made that finding. Now, there's one last thing I'd like to touch on. I believe Mr. Townsend may speak more about this, but regarding the firm point-to-point service, the argument has been waived. However, that rate that has been discussed, the border rate, that actually is subject to a pending proceeding before FERC. There has been a settlement that was certified by an administrative law judge in December of 2017, under which the rates to Linden and Hudson would actually increase. Certainly Linden, possibly Hudson as well. The rates for that point-to-point service will increase. And that was a negotiated settlement between transmission owners and Linden and Hudson.
And does that encompass the kind of transmission enhancement charges that we're talking about?
It does include some portion.
Different categories of costs.
Right, Your Honor, it does incorporate these transmission enhancement charges, not to the extent that, perhaps not to the extent that New Jersey.
No, but it's a category of it's a category of cost that you think is at issue in that proceeding.
My understanding is that it is. I do want to caveat that the settlement has not yet been approved by the commission, so the commission hasn't spoken to it. But my understanding is the parties, at least the New York parties, view those costs as being part of that border rate.
Judge Rao,
I'm getting the impression these FERC decisions in these cases are like a Faulkner novel. They just go on and on and on and on, with occasional orders being issued on which parties have to appeal, and you never put together the whole thing in one proceeding. And then you end up with different panels of the Court of Appeals deciding different parts of this. This is what I meant earlier when I said you seem to be slicing the salami very thin.
Larry, you don't want this appeal to get bigger, do you?
I think it's a good question. I think what happens is the same issue comes up
right
in such a minor different way. So it's not technically the same issue, but it's the same basic problem.
Any further questions from my colleagues?
No.
Thank you, Ms. Chu.
Thank you, Your Honors.
Mr. Townsend, last but not least.
Thank you, Your Honor. And may it please the court. I'll begin with where we just ended on the border rate proceeding. There is a separate proceeding in which all of the parties here are participants, and there is a certified settlement, and the border rate goes up 300% for the merchant transmission facilities. So it's a very significant increase under the certified uncontested settlement. And that increase pays for, 100% of it pays for regional plan costs, including the border rate. So it is simply not true that Linden is not paying for the corridor project. They
So
are
how much cost are they paying compared to their revenue?
That, Your Honor, I don't know the dollar amount. I know it goes up 300% over what it was. And so it's quite a substantial increase. And at the end of a 7-year period, it's much higher than that as well. And that was specifically put forward by the transmission owners after the merchant facilities gave up their firm transmission withdrawal rights, specifically to capture the cost of the corridor project and other regional plan projects. So this isn't a loophole. In fact, this was specifically identified in Opinion 503 back in 2009. I point to the court to footnote 7 of Opinion 503. It's at page JA 722, and it specifically says, merchant transmission facilities can give up their firm transmission withdrawal rights and separately take firm point-to-point service if they pay for it. And Linden is paying for it through the border rate. So if the court reaches the merits of the issue, that would be the answer. We don't think the court gets to the merits because of the jurisdictional bar.
So Mr. Townsend, is it your view basically that the settlement is, to the extent there's a loophole, the settlement is closing up that loophole?
Your Honor, I wouldn't agree that it's a loophole. This is something that has been identified since 2009, that merchant facilities can take different services if they'd like, as long as they pay for them. So it isn't a loophole, but to the extent transmission owners think that there's an underpayment, they are getting those costs through the border rate.
Counsel, may I ask a question? How long has it been since the FERC order that's being appealed here that gave you whereby you switched, or maybe even the earlier order, when you switched from a firm withdrawal to non-firm withdrawal? How much time has there been?
It was in December of 2017 that the merchant facilities gave up their firm transmission withdrawal rights.
Has there ever been an occasion where your withdrawal rights have been curtailed?
I don't know if actually there has been an occasion. That would be up to PJM, because the merchant facilities
yes, but it's also up to you. You know about it, of course, wouldn't you? My question is, goes to the proposition that the change from firm to non-firm is an illusion.
Well, so 2 points, Your Honor. With respect to Hudson has only non-firm rights, non-firm transmission withdrawal.
Is Hudson before us?
We think that New Jersey has waived its challenge with respect to Hudson. It has not identified any issues with respect to the Hudson order. So
yes, I think you're right about that. So I don't see why you're even talking about Hudson.
Only because they're differently situated. I'll go to Linden.
Just ask about Linden.
With respect to Linden, there is this argument that there's a pairing of non-firm and
has there ever been a circumstances where the withdrawal rights were curtailed?
I am not aware of a circumstance like that. That would be up to PJM, because PJM controls Linden. And so Linden is a control.
But also we up to Linden. You're representing Linden, so you would know, wouldn't you?
There's nothing in the record to talk about the factual history, Your Honor, but I would just say that it's PJM that controls Linden and whether service is curtailed over Linden. So if there's an emergency, a blackout, Linden would have the ability to control, PJM would have the ability to control the Linden facility. Whether that's happened since 2017, I'm sorry, I couldn't tell you, Your Honor, whether that's happened, but it could happen.
You make a good point. It's not part of the record, but I was just curious.
Yes, and so again, if the court reaches the merits, I think opinion 503 and the border rate completely answer the objection here. Again, I would just say with respect to the jurisdictional issue, there are 2 paragraphs in the complaint order that discuss New Jersey's pairing argument, paragraphs 58 and 59. You will find those paragraphs mentioned nowhere in New Jersey's rehearing petition. They're never cited. Other paragraphs around it are cited, not these paragraphs. New Jersey did not press this argument on rehearing. So we think there's a jurisdictional bar. Just very briefly, with respect to Con Edison, the court has recognized that there are very clear contractual rights here that Con Ed exercised. New Jersey agreed to them back in 2009. Con Ed is not liable for cost allocations after its term of service, and its term of service naturally expired in April of 2017. There is, under the clear language of the contract, there is no further cost allocation. And with respect, and Con Ed is not a customer of PJM today. With respect to the New York ISO, it had never agreed to pay for costs, a regional plant cost in PJM, and it had no notice that it might be liable for the cost of the corridor project. An involuntary allocation here to another region would be unprecedented. And it would be contrary to Principle 4 of opinion of Order 1000. And it's certainly not supported on the record here, because the record shows that this project would have been needed to fix a New Jersey problem regardless of power flows to New York. And I specifically direct the court to pages 460 to 465 of the joint appendix. PJM put in very detailed evidence showing that this project would be needed regardless of any power flows to New York. Even if those flows were zero, this project would have been needed. And so there is just no record here. And New Jersey put in no evidence to the contrary. There's no record that would support an involuntary allocation to another region.
Can I
And
just,
so, yes, Your Honor.
or just back to Linden for a minute? So you agree with FERC's current position, which is that for New Jersey purposes, when Linden downgraded its withdrawal rights from firm to non-firm, but simultaneously upgraded by acquiring point-to-point, that was giving up rights that mattered. But for purposes of the New York tariff, not giving up enough to prevent New York from reasonably saying your rights are still good enough to permit you to sell capacity in our markets. You agree with all of that?
I agree with that, Your Honor, with a small point, which is I don't think it was simultaneous. I think Linden took firm point-to-point service at a later date. But yes, I agree that.
But conditioned on the downgrade of the withdrawal right.
That's correct. And there was, as the court has recognized, there was a proceeding in which New Jersey was a party and did not seek judicial review, the New York capacity proceeding.
So what is that? What is in that delta? I mean, what is Linden giving up that matters, that could conceivably matter to Linden, if not the ability to sell energy and or capacity in New York? It's just, the intuitive argument on the other side, this is not an all-purpose energy company. This is a facility very specifically designed to transfer power from New Jersey to New York.
Well, I don't think we had the answer to the New York capacity proceeding when Linden gave up its firm transmission withdrawal rights. So there was certainly a question as to whether Linden could sell capacity into New York. But these are two different services, the firm transmission withdrawal rights and the firm point-to-point service. They're subject to a different set of rules, different schedules in the tariffs. They're not necessarily identical services. And the proceeding in New York about capacity was just to consider whether what Linden can provide is sufficiently firm for sale in the New York capacity market. And that turns on a number of factors: benefits from interconnection and reliability benefits, the fact that PJM can control the Linden facility. These were part of the rationale in the New York ISO proceeding. So based on all of that, FERC determined that it was not arbitrary. The New York ISO properly determined that they were sufficiently firm under the terms of the New York ISO tariff. But again, that wasn't a foreordained conclusion. New Jersey was making arguments in that proceeding and didn't seek judicial review. So there was certainly some risk here on Linden.
Okay. Judge Rao, anything else? Judge Silberman?
No.
Okay. Thank you, Mr.
Thank
Town.
you.
General Schierenbeck, rebuttal.
Thank you. Just a few points. I know it's been a long morning that are directly responsive to what we've heard. The first, Judge Silberman, on the question of Hudson, the reason why we did not spend much time on Hudson in our brief is because they're not pairing, but Linden is. And so that's the reason why you're not seeing much about Hudson except in our totality argument at the end of our brief. Now, I hear the commissioners have given two rationales for why allowing Linden to escape costs after conversion made sense. One was that PJM no longer had to plan for Linden, but what we can see in PJM's own manual, 581 to 82, is that they continue to plan for Linden just as they did before. We also know that PJM said now Linden service can be curtailed. And the specific thing they said was that as a result of this conversion, they will be curtailed according to level 3 standards. But what we know is that they will in fact only be curtailed to level 5 standards, which is the same as it was before. And that's what NISO said in the independent power producers order. And that is what NISO and PJM were explaining even in the order below. Now, to the extent that fact was only made crystal clear in the independent power producers order, that order came out after New Jersey filed for rehearing. So New Jersey would have had no opportunity to point to that specific statement in its rehearing petition. And I'm aware of this court's case law saying sometimes there are arguments that are only come to fruition upon rehearing, and you don't fault a party for not raising an argument, anticipating an event that didn't occur in its rehearing petition as a result. So that's another way of thinking about that waiver issue.
Isn't that really, that's an evidentiary question or a factual question that would support the argument, but still the argument could well have been made at the time you filed for petition for rehearing. You didn't need New York, the decision in the New York capacity market question in order to make that argument.
It's a fair point, Your Honor. I would say it's factual. It also goes to the reasoning on the face of FERC's order, but I think we did raise it in our allusion to the continued reliability and capacity benefits that New York ISO had itself talked about in the orders on review. To the extent I heard the commission say that our Linden challenge is a collateral attack on the Con Ed order, I hear that if that's what they're arguing, I think that's a new argument. I don't understand how that could possibly be true. That proceeding that was about the sort of operational base flow and whether that was a continuation of the Con Ed wheel was neither here nor there as to Linden, and we could not have anticipated that Linden would try this unique maneuver and be relieved of costs at that point. And Opinion 503, which I also heard the commission talk about, can't be dispositive on that issue either, because Opinion 503 occurred in a specific factual context, which is every merchant like Linden held firm TWRs. It's not until Linden tried this gambit that this this situation ever arose. And finally, as to the border rate proceeding, I again just want to point the court to 177 FERC 63027, and in particular paragraph 88, because they're in the border rate proceeding that they're alluding to and saying that's going to deal with these transmission enhancement charges. The ALJ has said transmission enhancement charges are outside the scope of that proceeding. So what you have again is FERC deciding every time a party brings a challenge to get at the core issue we're bringing up at Linden, the commission's answer is, well, I understand that's an ALJ decision that hasn't been adopted by the commission yet. So I don't want to overstate the matter, but what you find is FERC saying, well, that's outside the scope. We just can't look at that. And so that's why we brought a consolidated challenge, Your Honors, and we think it's properly before the court. If there are no questions, we rest on our papers. Thank you very much.
Thank you. The case is submitted.
This honorable court is now adjourned until Friday, March 18th at 9:30 a.m.